Welcome back, and to begin with, we're going to cover what's known as an agreement for representation. Now, the original Florida Bar contract that they provide for lawyers to use with their clients for legal services covers a lot of different areas, including personal injury, family law, and things of this nature. What we've done is we've taken out most of those things that don't relate to criminal law in order to simplify the agreement for representation so that it doesn't run on for 5, 6, 7, 8, 9, 10 pages. That's a little bit too much, and written plea agreements in felony court basically say the same thing about 20 times, and I didn't want to do that with our agreements for representation. So let's go down a list of various different things that are in all agreements for representation. First of all, we're going to list the defendant, the person we're actually representing. Now, at the same time, there may also be someone who's a separate party as a fee payer, and the fee payer will be listed as well. There are some attorney-client privileges that kick in, and so if you're a fee payer and not the client, we will need special permission from the client to speak with you about the case, but we also have to be very mindful about conflicts of interest, which are prohibited by the rules that regulate the Florida Bar. So that constitutes the parties. Then you're going to come to a section that talks about what the legal fee is based upon. And there's a whole laundry list of things that range from the amount of time it takes to the novelty of the legal questions presented in a particular case. So those are going to be set forth in your agreement for representation. There's also going to be an area that covers the distinction between a legal fee and a cost. So what is the difference? A legal fee is what goes to the law firm and the lawyers, whereas a cost is what what someone pays, what goes towards defense expenses. If a court reporter is needed to take deposition testimony, which is sworn testimony, similar to court but different in that it has a much broader scope, then they will charge a fee. If we need an expert witness, they will charge a fee. So a legal fee is completely separate from a cost. You can imagine that they're on two sides of direct midnight on a clock. One side is costs, one side is fees. Now, many lawyers take a deposit against expenses for costs. Sometimes we do that, sometimes we do not. Next, you'll notice in the fee agreement there will be a section regarding other lawyers working on your case. Virtually everything that we do is a team effort. Why is that? Well, a lot of lawyers don't want to pay to have another lawyer working on the case. In reality, there are no such thing as super lawyers. They don't exist. And my belief is, and has been for a long time, that Rule 3.112, a rule of procedure you've never heard of, but talks about capital cases, this rule requires a second lawyer in a death penalty case. And I think, as a matter of practice, procedure, and policy, it is always good to have a second lawyer looking at your case, whether it's a felony or a misdemeanor. I'd love to tell you I'm a super lawyer and I wear a cape and that I can magically make things happen, but you know what the reality is? It's hard frickin' work that makes the difference. And with having a second set of experienced eyeballs on a particular pleading, research, etc., that can make all the difference in somebody's criminal case. So virtually every case that's handled by the firm is handled by a team. Does that mean I'm not involved? Not at all. I personally supervise each and every case. I just want to make sure that you or someone you love gets the representation that they deserve. And the way to do that is to dot all the I's, cross all the T's, and to do it correctly. Thus, we've basically expanded Rule 3.112 to every single case because I think you deserve the best representation. Next, you'll notice a section in the fee agreement that is going to talk about refunds. And the reality is there are no refunds in criminal defense, that the fee is earned upon retention. This is language that comes directly from the Florida Bar. Now, why would we do that? Well, it's very simple. In criminal defense law, if you don't get your fee up front, you don't get paid. Next and finally, you'll notice that there is a supplemental section that talks about additional fees for unneeded appointments. What am I talking about there? Well, this is because sometimes people will want to have a chat session or an emotional mental health therapy session rather than use coping with stress during criminal prosecution. This is called how to waste your lawyer time and destroy your legal fee. We don't think that's a good idea. When you're eating up legal fees because of stress and you're asking the same question over and over again, or you're not asking questions at all but simply venting stress, that tells us immediately that you're not using the stress protocol. Now, I understand that some of the biggest power firms in the world do not use a stress protocol. They would rather have you come into the office for an office chat because they teach their lawyers through practice managers to sniff out opportunities to upsell you, to resell you, and to cross-sell you additional legal services. Personally, I think you retained us to produce a result, and we cannot guarantee a result. In fact, that is prohibited by the bar. But what we have to do is make sure that we have a system for everything, including stress. So if you want us to be mental health therapists, number one, we are not qualified, and number two, it wastes your legal fee. Number three, it takes time away from defending the case. So in those scenarios, when people want that extra time that is not necessary for keeping the client informed, that is not necessary to answer questions related to the case, then we are going to charge additional. And our goal is not to charge you additional at all. We don't want to do that. What we do want is for you to use the protocol coping with stress during criminal prosecution. So these are the elements of a standard agreement for representation. They're going to be slightly different in your case, just like they're different in other cases, because your case may be a misdemeanor, maybe a felony, maybe a violation of probation, maybe a violation of community control. But whatever it is, these are the basics of your agreement for representation. And if you have any questions about it, by all means, contact us. Call us on the priority number for existing clients and talk to one of the lawyers, and I'm available to discuss your agreement for representation.